You are not going to sit here and try to disparage that man. I'm not going to believe it, and I'm not going to hear you. I'm not going to hear you.
And what he's engaged in is third-party communication to get through to Mr. Quasney in violation of his bond. That's number one. He's got a no contact order. Second, this is witness tampering. You don't want to call it extortion.
I'm just letting you know that what I'm hearing is extremely disturbing.
I completely understand that.
And so, Courthouse case, People versus Larry Lee.
Good afternoon, Your Honor. Mary Tanha, Assistant Prosecuting Attorney about the people.
And Mary Rubio, on behalf of Mr. Lee, I am standing in for the attorney of record, David Burgess, with Mr. Lee's consent, to my knowledge. Is that correct, sir? That is okay for me to stand in for you right now?
Yes.
Okay, could you please state your name?
Thoroughly.
What is that noise?
Right. Shouldn't you check? I don't feel safe. Why are you just pointing? What?
Don't stop. So.
It'll stop at some point.
I feel very safe, Your Honor.
Wow, I know. He's like, you are all over it. All right, go ahead. What are we doing?
Well, Your Honor, a few things. First of all, I've been in communication with Mr. Burgess and Mr. Arabo, who is representing the victim of the case, Mr. Quasney. Apparently, Mr. Lee called Mr. Arabo and offered to, in exchange, there's a pending case where Mr. Quasney is the defendant of an AMD against Mr. Lee. Mr. Lee contacted Mr. Arabo and offered to essentially not testify in that case if Mr. Quasney agreed not to testify in this case. There are statements that are essentially saying, in exchange for Mr. Quasney, victim in this case, not testifying, I will also not testify. That is highly concerning, of course. I was given this information yesterday. I asked Mr. Arabo to forward that call to myself, Mr. Burgess, and the officer in charge because we want to document the potential additional charges. But this all transpired yesterday. We got the recording as of this morning. With that said, of course, I think it's appropriate to have an adjournment. Mr. Burgess agrees with that.
But does that recording indicate that?
Yes, Your Honor, have either one of you listened?
I myself have not listened to the recording. I was just asked to stand in on behalf of Mr. Burgess. He's at a hearing in Lansing. However, I did speak to Mr. Lee about it today. Mr. Lee indicated some of the content of the conversation to me. He also indicated, just FYI, that he himself recorded it.
But just so that I have this right, the defendant, because of something else, is urging, enticing, or in some other way interfering with testimony of witnesses in this case.
I can't agree to that characterization because I haven't heard it. I don't know.
Well, you want to listen to, because that's what I'm being told.
But yes, I understand. I understand that is what's being presented. I also want to indicate that. Go ahead. I'm sorry. Mr. Lee has indicated to me some things. I have advised him to be careful of what he would want to say to Your Honor, but he seems to feel that he needed to make that phone call because he wants to move to have Mr. Burgess removed and he wants to get a different attorney. Mr. Lee has indicated to me he also wants to address the court. I again did advise him I would not go into the content of that conversation as there could be potential pending new charges. With that said, Mr. Lee, what is it you wanted to say?
Yes, Judge, I indicated to, what's her name?
Ms. Rubio.
To Ms. Rubio that for a little bit over a month, I contacted my attorney, Mr. Burgess, and I instructed him to contact the lawyers from both sides, the prosecution and the other side that represented Mr. Quasney, and I instructed him to offer a plea or to negotiate some sort of settlement, and he indicated that he would do that. He indicated that he had done that. He indicated that he had reached out to Mr. Arabo and the prosecutor regarding making some sort of plea agreement. Him and I discussed what that could be. And so now, fast forward, yesterday, I contacted Mr. Burgess and I said, hey, have you reached out or have you heard anything from Mr. Arabo and the prosecutor? He said, and he indicated that he had not heard anything and that he had reached out to both attorneys multiple times. I knew that to be a lie. I suspected that to be a lie. And I knew that if I were to have him or to ask you to have him removed or substituted, that I would have to prove under Strickland versus Washington that he.
I don't know. Are you a lawyer?
I was,
Mr. Lee, no, to my knowledge, no.
so I knew that I had to prove that he was ineffective. I knew that I had to prove that our breakdown was egregious. So I recorded the call myself. And I called Mr. Arabo and I asked if Mr. Burgess reached out and discussed any sort of plea negotiations. Mr. Arabo said, no, sir. He had not had any communications with my attorneys. So I confirmed with Mr. Arabo that he had not received any communications about any kind of negotiations with any kind of plea agreements on my behalf.
I'm so sorry to interrupt Mr. Lee before he makes more statements.
And I did record the.
That are false to this.
I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements. In the call that was sent to us, there is indication there's no discussion of a plea, not what was sent to me. That was recorded by Mr. Arabo. There's very clear that there will be no testimony in his case if Mr. Quasney agrees not to testify in this case.
So I have the text messages.
Further false statements are made to the court, which is not necessarily a problem for me, but I want to make sure that Mr. Lee's rights are preserved.
I have the text
He
messages.
might want to listen.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because if he's interfered with it, that's going to be a whole other issue.
I will try to reach him, but I know he is in Lansing, so I'm not certain.
Well, even if he appears, right, has Mr. Burgess heard the calls?
I don't know, Your Honor. They were sent this morning. I asked Mr. Arabo to send them right away yesterday, and we received them this morning. Mr. Arabo can also be available via Zoom if necessary.
All right.
Okay.
I'm just letting you know that what I'm hearing is extremely disturbing.
I completely understand that. Your
And
Honor.
so I'm gonna give an opportunity for the defense to give me some explanation, but I'm inclined at this point, I'm gonna hold him in custody. I'm inclined at this point to revoke his bond.
I understand.
Okay?
Okay.
All right.
Thank you, Your Honor.
Thank you. Can we get Mr. Lee out? No, oh, is he? Okay, great. Court does call the case of the people versus Larry Lee.
Good afternoon, Your Honor. Marie Tin, Assistant Prosecuting Attorney on behalf of the people.
I forgot to wait a second.
And Mary Rubio, again, on behalf of Mr. Lee, who is making his way to the podium.
There's additional counsel that is on Zoom.
I'm sorry.
Mr. Rubio. Oh, there you
Good
are.
afternoon, Your Honor. May it please this honorable court, Joseph Arabo on behalf of Stephen Quasney.
All right. And I'm presuming everybody except the court has heard the phone call.
What I heard was the recording the prosecutor gave me, which appears to be a less than 2-minute portion of a phone call. I think she would agree it's not an entire phone call.
That's correct, Your Honor. It's what Mr. Arabo sent me, as well as Mr. Burgess and law enforcement this morning.
All right. And that portion of the phone call, as the court is to understand, is basically this defendant speaking with, is it directly with the victim in this case?
No.
No,
An
Your Honor.
attorney.
It's with Mr. Arabo, who's the attorney for the victim.
All right. and basically offering to not provide testimony in another case if his client doesn't provide testimony in this criminal proceeding.
That is how I would characterize it, Your Honor. If Mr. Arabo has additional information or different information, he's welcome to.
Yes, Mr.
Yeah, just to clarify the record, that's a portion of a phone call because I didn't anticipate to record the entire thing. I didn't know who was calling me. And then once I realized what this was, which is an attempt to extort and use this other case that he filed against the victim in this matter to use as leverage to have this conversation at a future point in time, I was quick enough to get on my computer and record it so that the court is aware of what's going on in the matter where I represent Mr. Quasney, who's the victim in this matter, which is the first matter before the court.
Your Honor, if I may, I really object to that characterization that it was an attempt to extort. I've spoken to Mr. Lee at length about the purpose of the phone call. I also listened to the portion of the phone call. Perhaps the court could listen to it. I do not believe that that was what was happening at all. And plus, I don't think there was nothing on there that indicated he was trying to extort this attorney or the complaining witness. Frankly, what Mr. Lee has alleged to me is that he and Mr. Burgess have basically had a breakdown of communication, that he's spoken to Mr. Burgess multiple times, asking him to advocate on his behalf to the prosecutor as well as to this other attorney to try to come up with what he has called, not being a lawyer, using the words a settlement agreement or a plea negotiation. That's what he said to me. And that he had the feeling that Mr. Burgess had not, in fact, made this phone call. So he then called this attorney, and right in the phone call,
because it would have been unethical for Mr. Burgess to call to try to say my client won't testify in this other matter.
Of course.
If that, right? That's
well,
Mr. Burgess may not have done.
And that may very well be. But Mr. Lee indicates that, and I haven't seen these, he indicates that he has text messages back and forth with Mr. Burgess, and that Mr. Burgess, quote, lied to him about whether or not he made these phone calls. So he indicates the main reason that he wanted to call.
That would be irrelevant.
I know that. Judge, trust me. I know that. But I just wanted to make a record. What, can I just finish though?
Let her finish.
Mr. Lee indicated the main purpose of the phone call was for him to find out whether this attorney could verify whether Mr. Burgess called him. If you listen to the call, the portion of this call, it's literally on there. He says, it starts out with him saying something about plea agreements. It's the call, it's interrupted. And I believe because counsel didn't realize he was going to need to record this. But anyway, it starts out with him, Mr. Lee, saying something about plea agreement, settlement agreement. Was there any, did Mr. Burgess call you to try to, see if I wouldn't testify and then your client wouldn't testify? Yes, he says that. But then he goes on to say, because my lawyer said he called you, and then this attorney confirms what Mr. Lee was trying to find out. And this attorney says, no. You see how easy it was to reach me. I didn't talk to anybody named Burgess. That's what he says. So I'm just indicating that Mr. Lee states that was the main purpose of his call, because he claims he wanted to come in here today and tell Your Honor that he did not want to have Mr. Burgess represent him anymore because he feels Mr. Burgess is lying to him. I'm just representing to you what Mr. Lee has told me.
Your Honor, if I may.
I'd like to say something.
Thank you. Mr. Arabo, it's my turn. One moment. Your Honor.
Because apparently that's how it works in this courtroom. Tana says it's her turn, so it's her turn. Go ahead, Miss Tana.
Mr. Arabo had some trouble with the
That's only because she's there and I'm not.
Your Honor, I don't really, quite frankly, care what's going on with the client relationship with Mr. Burgess, or Plaintiff Mr. Rob was making about extortion. That's not something that people are going to get involved in at this stage. What I'm concerned about is there is a clear difference between a plea negotiation and two witnesses not testifying, one of them being Mr. Lee, the other one being Mr. Quasney, not testifying in exchange for something. And I agree that the court should just listen to the call rather than us going around calling it different things. What's clear to me is that there is an offer to not testify in exchange for Mr. Quasney not testifying in this case before this court. That is what I'm hearing on that call. That is what's concerning to people, and that's what may bring future charges. We're in an early stages. This needs to go to law enforcement. It has gone to law enforcement now, and we can follow up.
Mr. Rubble.
Your Honor, as you know, I'm a defense attorney. I think Ms. Rubio is really grasping at straws here to try to help her client. But here's what it is. It's not a plea. We heard her say plea. A plea means a reduction to something other than what is being charged with, not a dismissal, which is clearly being indicated in this. Second, what's happened here is you could see clearly there has been a subsequent case filed. I don't know how to slip between the cards because in over 10 years of practicing, I've never seen something like this where a victim turns into a defendant. What? During a pending case. Never seen anything like this. So Mr. Lee has done this intentionally so that he can one day use it as leverage to contact me or have somebody else contact me or whoever is representing Mr. Quasney so that he could use it as a negotiation tactic. And what he's engaged in is third-party communication to get through to Mr. Quasney in violation of his bond. That's number one. He's got a no contact order. Second, this is witness tampering. You don't want to call it extortion. Let's find something else. It is witness tampering. He's trying to tamper with Mr. Quasney using the leverage that he created. And I don't know how the prosecutor's office allowed this to happen. Somebody wasn't monitoring things properly, but this is what's happened. First ever time I've ever seen anything like this. And it needs to be handled. It needs to be handled. It's going to be handled.
Okay.
Can we listen to the call?
Everybody
Yes,
listen to it already.
Can somebody send it to Ms. Weidling and I will then be more than happy to listen, or if there's an easier way for me to do it, I'll do it. Let's take the defendant back and court to listen to the call. I can give my decision.
You have to go back.
To you. Court does recall the case of the People's State of Michigan versus Larry Lee.
Good afternoon, Your Honor. Marie Tan, Assistant Prosecuting Attorney on behalf of the people.
And Mary Rubio on behalf of Mr. Lee, who is approaching.
Get your name, please.
Larry Lee.
Okay. The issue is in this case that, first of all, we're adjourning the hearing over.
I believe we are. That was what I thought we were doing in the beginning.
Well, it's got to stay before me. So.
I know Mr. Burgess is already going to be here on July 1st. I just wanted to put that out there.
Yes, but I'm not on the.
Oh.
I'm on the bench, but I'm not doing these.
Okay.
So. Set his preliminary examination July to defendant's request. So my next date is July 22nd, 2025, and that's another 12 p.m. start because God, I love that. All right. With reference to bond in this case, I've listened to the recording. I'm not going to say there's an over exaggeration or an under exaggeration. I mean, I think it's relatively clear when somebody very clearly points out an exchange or quid pro quo regarding me not testifying and this other person not testifying, and that is the exchange. I don't know that you get a clearer indication of somebody that is attempting, and especially when they circumvent their attorney, of somebody trying to sort of tamper with and obstruct a case. It couldn't be clearer. I mean, and quite frankly, I don't think there's any design to necessarily frost it over or anything along those lines. I think the idea or what Mr. Lee is saying about what Mr. Burgess wouldn't do is quite frankly just a ruse to hide his own desire to have the exchange that he was speaking with counsel about. Given that, and the court having heard that, with reference to this case, the defendant's bond is hereby ordered revoked based upon the court's hearing of that bond violation.
Your Honor, can I just raise two issues? Before all of this happened, Mr. Lee expressed to me and attempted to express to the court his, as I'm sure the court has gleaned, his displeasure with Mr. Burgess. So I do think there, given some of Mr. Lee's allegations against Mr. Burgess, it may be best if someone else is appointed to the case. I know he doesn't want
So,
Mr. Burgess.
And that's fine. I don't know whether or not he doesn't want Mr. Burgess or not, because I think, as I'm indicating, I think that notion of Mr. Burgess not doing something and then his checking is simply a ruse for him to try to get the message that I want this quid pro quo, this exchange.
And I'm not accusing Mr. Burgess of anything. I'm just trying to represent what Mr.
No,
Lee has
and
told me.
I understand that.
And Mr. Lee is
I think
about
when
jumping
you-
out of his skin trying to talk, just so you know.
And so when you talk to Mr. Burgess, if Mr. Burgess, if he believes that that's the appropriate step, he can bring that motion before this court and the court will hear it in
Okay.
the day that I'm on. Mr. Lee, I will let you talk in a moment, but I'm going to finish this. Revoking your bond because of what is a clear violation of the bond regarding, and I mean, I think it's an attempt to try to get indirect contact as well as obstruct these proceedings. Because that was accomplished in the manner it was, and I'm not sure that I can trust you with reference to no context and the like, we're at least going to get through this. I am going to, subject to a hearing, defendant's phone privileges for the jail are also revoked. What did you wish to say, sir?
The thing that my substitute attorney here didn't convey to you was that I told her that I have the evidence with me in hand, that my attorney, Mr. Burgess, was the one that actually said that this was a legal way that we can go about it. And no, I'm not.
You know what, Mr. You might as well stop right now.
I have the text.
Because no, I'm going to tell you, I don't know if you're misunderstanding something or what, but you are not. Mr. Burgess has appeared before this court. You are not going to sit here and try to disparage that man, saying that somehow or another, Mr. Burgess represented to you that obstructing a case in this fashion was a legal way to proceed. I'm not going to believe it, and I'm not going to hear you. I'm not going to hear you. I don't know how do you not understand what I'm telling you? Now, if you've got that information and you think that's what it says, you get it to counsel and the court will take a look at it. But you're not going to sit here and disparage that man. It is not going to happen. I'm done. Bond revoked. Take you.
Thank you, Your Honor.
They were ready. Court does call the case of the People versus Larry Lee.
Good afternoon, Your Honor. Marie Tanhouse, Assistant Special Attorney, the People.
Good afternoon, Your Honor. May it please the Honorable Court, David Burgess, currently representing Larry Lee.
Your name, sir?
Larry Lee.
All right. Mr. Burgess.
Your Honor, based on representations or communications I received from the court, Your Honor, I filed a motion to withdraw. I also received a letter today from Mr. Lee that the court made me a copy of, indicating he wants to represent himself. So based on the motion I submitted as well as this letter, I'm asking the court to allow me to withdraw as his counsel.
And just so that the record's clear, the court received from Mr. Lee what were, in this court's opinion, I did not read them fully and only had a staff member relay them to me, were, I would say, privileged communication to the extent the privilege would still exist between Mr. Burgess and Mr. Lee. That is what I, based upon looking at them, what I presumed that they were. That is what I presumed that they were. At that juncture, I informed counsel that I had received them. Because I had viewed them as privileged, I had indicated that I would not let the people see them, but that Mr. Burgess could come by our office and look at what had been received. Shortly thereafter, I received Mr. Burgess' motion to withdraw. And basically that was going to be heard today. Almost immediately thereafter receiving that, I then received in, I guess, in our office mail or however it got to me, a letter from the defendant saying all kinds of different things, but indicating that he did wish to represent himself. That letter that he sent was shared with both sides. Today, I provided a copy to the people and also to Mr. Burgess in this case. All right. Is anything from the people?
Your Honor, just that I've spoken to Mr. Burgess about this matter. I don't have an objection to this motion. That's of course discretion. As far as I'm concerned, we've had communications about this case. He has fought diligently for his client.
All right. Mr. Lee, do you not wish Mr. Burgess to represent you in this case?
That is correct, Your Honor.
All right. And the other thing, you wish to represent yourself? Or do you wish the court to sign an order that permits the Office of Manager Assigned Counsel to appoint counsel to represent you?
I would like the latter.
So you want new counsel?
Yes.
So you want at this time and I think it's on page 2 of your communication indicating that you wanted to represent yourself. You want the court to disregard that at this time?
Yes, sir.
You understand that because I'd be appointing new counsel, that's going to require that this matter be adjourned to allow counsel to get up to speed on your case.
Okay. I was unaware of that. Are we talking a 1 month or a 2 week adjournment? Just curious.
Well, it's wherever the court, I've got a very tight schedule, but we will, what day?
August 19th, Your Honor, would be the date.
It would go out approximately a month.
Okay. I have some upcoming surgeries. And so I will then like to just represent myself because I don't, they're very serious surgeries. And so I don't have the time to
Right.
wait.
I understand that, but when do you think, if you represent yourself, when do you think your examination would be?
I would object to any further delays, and I would like as soon as possible convenient with the court and everyone else. I'm prepared.
You're prepared to what?
I'm prepared to take the first available date for the examination as soon as possible.
Well, I don't know what you're asking me to do, Mr. Lee. Have you reviewed all of your discovery and everything?
As far as I know, the discovery was just 2 pages of the interview with the detective and the victim. I have reviewed
I'm
that.
going to probably believe that there's more than just
Correct.
2 pages.
Correct, Your Honor.
I just provided copies too, Judge. He was at my office in May 8th.
So I would need copies of that.
I mean, Mr. Lee, you're not, Would I be correct that you are not prepared to go forth today to preliminary examination yourself? I mean, because you keep going back and forth, you want counsel, then you want that.
So I am prepared to go today. Absolutely.
If you represent yourself, you're prepared to go forth today?
Yes.
So what do you want me to do, Mr. Lane?
I would like to proceed today.
Okay, you understand that it cannot finish today.
Sure. I agree. It's fine.
Would the people have a witness they can start with?
Your Honor, we have a witness we can start with. I will say from the record, I do have concerns that if Mr. Lee is going to be representing himself, he's doing so without having all the discovery. And he, of course, will be held to the same standards as any attorney would be held. So a lot of concerns from the people, but we do have a witness available if that's what the court is inclined to do.
Is that really what you want to do, Mr. Lane?
Yes.
I think I'm going to be honest with you. I think you're just telling me yes, thinking that you're going to get a quicker date. And I am not clear that you're ready to go because you only talked about 2 pieces of paper and counsel's telling me there's a whole lot more in this file.
I understand.
People can become overconfident when they do not yet understand how much they do not know. Here, the rush to represent himself creates a strategic trap. He wants speed, but he has not reviewed the full discovery. In court, confidence cannot replace preparation, and self-representation means he carries the same burden as an attorney.
I'm willing and ready to go
Do you
today.
have a copy of the discovery?
My attorney hasn't provided me with a copy.
That's not true, Judge. I gave it to him on May 8th. At my office. He got
Or the 2 pages, yes, that's what I have.
No.
The other stuff I don't have.
Your Honor, for the record, not only is there a full police report, but there's also body camera footage that, again, it might be best to review before.
Have you seen the videos, Mr. Lee?
Well, I was there. I'm assuming they're referring to the body cam footage at.
Well, I don't know. You're making assumptions about what exists, and I don't know. Have you seen the body cam footage, Mr. Lee?
No. If you're, no.
Do you still? Ms. Wiley. Would the people be available? It is going to be a mess on the afternoon of the 8th. It's a Friday.
Your Honor, I should be available. And I have a double. August 8th, Your Honor.
Yes, ma'am.
Yes, Your Honor.
All right. Are you gonna be able to, so if I set it on the eighth, sir, and I'm sort of pigeonhole you in on a Friday that I normally wouldn't hold them, but if I do the eighth, are you still wishing to represent yourself or do you wish an attorney?
I'll represent myself.
Your Honor, the one thing I would like to add, because as I stated, we were ready to proceed today. The victim is here on this visitor's waiting since this morning. Victim has also been here previously, ready for exam. I would just ask that we have no further delays on the 8th.
Yeah, if I'm gonna be done, if you're saying, Mr. Lee, that you're representing yourself and I set this on a special date, I'm not going to at that time, if you wish an attorney, then I'll have to deal with that, but I'm not going to let a delay happen. Okay, we're gonna go on the 8th.
Yes, Your Honor.
Is that what you want to do?
Yes.
All right, I'm just,
Double checking. Days works.
pardon?
Days works for the people.
All right. So that's what I would set. I will advise you at this time, Mr. Lee, you understand that you are charged with the offense of criminal sexual conduct in the 4th degree involving force or coercion. You understand that, sir?
Yes, sir.
And that involves a Stephen Quasney. You understand that, sir?
Yes, sir.
You also understand that this is a high court misdemeanor, punishable by up to 2 years incarceration, a $500 fine plus court costs, mandatory HIV and STD counseling, and DNA was taken or have been taken upon your arrest. You understand that, sir?
Yes, sir.
You understand also that this, under the SORA statute or sex offender statute, is a tier 1 offense and would require registration if the victims are 18 years or older. You understand that, sir?
Yes.
All right. And also other requirements, but I'm presuming that the victim is, that's the only one that would be applicable in this test, in this case.
Yes, sir.
You understand all of that? You understand that if you proceed to represent yourself, you do so at great peril, and usually doesn't not necessarily work well for people when they represent themselves, but you are constitutionally entitled to represent yourself. You understand that?
Yes, sir.
You understand also that the court is going to make the assumption or presumption that you understand the Michigan court rules and the procedures used in a courtroom. You understand that, sir?
Yes.
You understand that the court would not be there to assist you in any way regarding this case. You
Yes.
understand that, sir? And you understand that you will not be, the court is not going to treat you worse and not going to treat you better than any attorney or the prosecutor in the case. You will be held to that same standard in conducting this.
Yes.
All right. Understanding all of that, you still wish to proceed representing yourself, sir?
Yes, Your Honor.
All right.
Your Honor, just for clarification, does the defendant want standby counsel?
He has not asked for it. I'm not offering it.
I'll take one if it's available. Thank you.
Well, there's going to be a funding issue regarding that. I'll make that determination as to whether or not there be standby counsel, because that can be done elsewise other than this. I will adjourn the preliminary examination in this matter to August 8th, 2025 at 12 noon. That's before me.
Bond violation will follow.
Yes, because that and the bond violation. Yes.
The defense is requesting, you to, examine the information between myself and my attorney, because I am alleging that I did not violate the bond, the condition of the no contact order of my bond, and witness tampering that the prosecution says that I'm guilty of, and the text messages prove.
You're asking me to look at information that would be relevant to the bond hearing?
The text messaging between myself and my attorney, and then the Google AI searches that prove my motive and intent for making the phone call between myself.
Sir, and you're asking me to look at it in reference to the bond violation.
Yes, because I think it should be reinstated.
I will address that on the 8th.
Okay, thank you.
Okay, I'm not making a guarantee I'll look at it or not. I don't know whether or not it's relevant, but I will deal with that on the 8th. At this point, his bond will continue. Thank you. Court does call the case of the People of the State of Michigan versus Larry Lee.
Good afternoon, Your Honor. Retail Assistant Prosecuting Attorney on behalf of the people.
State your name, please, sir. Mr. Lee, you are here for your preliminary examination. Sir, you have elected to represent yourself. Is that still your wish, sir?
Your Honor, I have not received any of the requested discovery material. I sent out written requests for the prosecution and my previous attorney and haven't received anything. So at this point, I'll be needing an attorney to assist, to represent me.
Your Honor, if Mr. Lee can maybe put on the record where he sent that request. I have not been informed of the discovery request from him. My understanding was that Mr. Burgess had a discovery materials.
I sent it to 200 North Main Street.
But well, there are two issues really involved. You sent out that you wanted a copy of your discovery.
That's correct.
Are you indicating that Mr. Burgess did not provide or share with you your discovery?
Correct. I sent out one to the prosecutor and one to Mr. Burgess.
Now, I'm asking a different question. At the point in time that Mr. Burgess is representing you, are you saying that he did not share the discovery information with you?
The only thing that I received was a police report, a 2-page report. That's it. So I didn't receive the file that he was referring to last court hearing. I didn't receive that now.
All right, let's just cut through the games and charade here. Do you wish to be represented by an attorney?
At this point, yes, I don't have any material.
Well, it's not an issue of the material. Do you wish to have an attorney represent you?
Yes.
Okay, under the court rule, he is entitled and can ask for that at any point in time. This is probably going to cause great inconvenience for people, and now here's the weird part of the system. While Mr. Drukas, I've appointed as standby counsel, I need you to get to the MAC office and see what we can get. All right, take it back. We'll get that resolved, figure out what the MAC office wants to do.
When we come back, I just want to make sure I don't forget, there are a few things that you want to address that happened after the last court hearing. So we can do that when we come back.
Something that happened after the last.
Yes, Your Honor.
You were just full of surprises. Fine, I'll deal with it then. Court's going to stand in recess.
All right.
Court does recall the case of the People versus Larry Lee.
On Retail Assistant Prosecuting Attorney on behalf of the people.
Good afternoon, Edward Drukas on behalf of Larry Lee.
All right. And Mr. Lee, I've signed the order appointing Mr. Drukas to represent you in this matter so that you're aware. Okay. All right. So in this matter.
Set for a preliminary examination, I'm asking for a brief adjournment. I understand through timing with the court that Monday morning would be available. If we could set it for that time.
All right.
Opportunity to go over discovery.
Will that work for the people?
Yes, Your Honor. We'll have witnesses present.
All right. So preliminary examination in this matter will be adjourned. Court finding good cause to do so. I will adjourn it to what is it, the 11th?
Yes.
August 11th, 2025, 9 a.m.
Thank you, Your Honor. And, when the court's ready, I have a couple of matters to put on the record.
Yes.
Your Honor, first and foremost, after the last hearing we were here for, The victim was present with a support person. As they were leaving the courthouse, they were addressed by someone who identified themselves as the friend of Larry Lee. I believe that person is now sitting in the gallery here today. I've personally warned her, but I would appreciate it if we could repeat that on the record, that the victim is not to be talked to or contacted. I don't have anything indicating that Mr. Lee directed that contact, but I want to make sure everybody's clear so we don't have any further issues regarding contact with the victim of this case.
All right, and which individual are you referring to?
This lady right now.
Ma'am, if you come out this way, please. What's,
Hi.
hello, what's your name? Yeah,
Hello, Your Honor.
what's your name?
I'm Jeanette Thompson.
What did you want to tell me?
Okay, so just to begin here, I'm very respectful. I don't know nothing that happened. When the I believe it's the victim was walking out, he was staring at me and I'm with 3 different women. And since he was staring at me, I said, are you so-and-so? I could identify him. So I think he was just irate because of what he going through. I don't know. But to be honest, I don't know that man. When he was talking, he was using verbal language. He walked back towards me and 3 other women and was kind of upset. And I said, I just want to know if you okay. My bad. I could identify him. That was all it was. I just said, I just want to know you okay. I don't.
Okay, so just stop it right now.
Yes.
So I don't want you to have any contact with the alleged victim in this case whatsoever. It doesn't matter if you are worried about whether or not they're doing okay or anything along those lines. You just not to have any contact, because ultimately, while the people don't have proof that Mr. Lee's involved with that, it could be attributed to him in regard to the behavior, and I don't think you want that to occur. All right. So I don't want any contact whatsoever. I understood.
Yes, sir.
All right. And if I do find out there is, at minimum, I would have you report.
Well, please, can you tell him not to walk up on me
I am
again?
not gonna tell him that.
Okay, because that was
You are, well, hold on. Here's part of a court proceeding.
right.
You are not.
Correct.
So you need to, if it's necessary, you need to get out of his way. There's court security if that
Got it.
becomes an issue for you.
Okay.
Or you can just make the election that you do not need to appear. If you want to see the proceeding that is happening with Mr. Lee, then certainly you may view that on YouTube. So there isn't a reason for you to be here.
Mhm.
There is a reason for him to be here.
Got it. Okay.
Understood?
Yes, sir.
All right, thank you. You can have a seat.
Thank you, Your Honor. One other thing regarding the discovery request that Mr. Lee said he had sent one to our office. I just received the email. It was labeled a FOIA request, so it went to our appeals and FOIA department. It appears it's a mix of, and I'll make sure to share this with Mr. Drukas, but essentially, it appears he is attempting to FOIA communication that I may have had with the court, that I may have had with Mr. Burgess. There's also a grievance/investigation request looking to, it appears, grieve me, potentially more people. I haven't read through the whole thing. Somewhere in there's mention that he wants anything related to this case, but the overall idea and heading is FOIAing all communications that have happened in this case, as well as attempting to grieve myself and potentially other people. So I know at this point, Mr. Drukas is appointed. He'll get all the discovery. We've been in communication. I've asked our office to expedite the video discovery to him. I handed him a report that's unredacted, but it is the full police report. So we'll take care of that. But perhaps there should be a conversation Mr. Drukas wants to have with Mr. Lee about the rest of it and anything that may or may not be brought up as part of this case, and that the grievance process is a separate process, which he is entitled to.
Right. If that's what he wishes to do. All right. Anything from over?
Nothing further.
All right. Very good. Thank you, folks.
Thank you.
Everybody have a great weekend.
Thank you.
Bond will continue at this time. We'll see you Monday morning.
What makes this case important is that the consequences did not come from one dramatic moment. They built through a series of decisions. First, the defendant contacted an attorney connected to the other case and discussed an exchange involving testimony. The court then treated that conduct as a bond violation and revoked the bond. The key issue was not simply what he believed his purpose was. The problem was how that decision affected the court's ability to protect the case and enforce its no-contact conditions. Then the strategy shifted. He wanted his attorney removed, considered representing himself, changed course, and later asked for an attorney again. The court allowed that change, but the record shows why preparation mattered. He said he had only received limited material, while the prosecution said there was more discovery, including a police report and body camera evidence. That creates an important lesson about sovereign citizen-style thinking and courtroom strategy. Challenging the system does not remove the system's rules. A person can question the process, reject counsel, or choose to proceed pro se, but the legal consequences still apply. The third appearance shows the practical result. The defendant ultimately requested an attorney because he lacked the material he believed he needed. The court appointed counsel, and the preliminary examination was pushed back so the new attorney could review discovery. Across all three appearances, the pattern is clear. Each decision created another problem that had to be addressed before the underlying case could even move forward. And that may be the most important part of this entire hearing. The case keeps getting delayed by decisions surrounding the case itself.